Welcome to the Stroh Political and Economic Podcast. Today we're going to be debating the US Constitution. Subsections are, is there an imperial court, and strict versus loose constructionism. I'm Khai and I'm a strict constructionist. We have Aaron.
And I'm a loose constructionist.
We have Robert.
And I'm a loose constructionist.
Abby.
I am sitting on the fence because I am just like Jeremy Corbyn.
And Ollie.
I'm also sitting on the fence.
Okay, so I'm going to go first because no one else wants to. We're going to start on strict versus loose constructionism. So my first point is going to be you cannot interpret what is not there. If it's not in the Constitution, then it's either up to Congress to make an act, you go through the Constitution's rules over amendments, or you it's a state's right. So at times when the court makes their decisions and people try and interpret the Constitution, the issue is that if it's not there, then you're adding parts to the Constitution which aren't there. And I'll keep my point short so someone else can make theirs. Anyone want to? And we'll go to Abby.
I mostly agree with you on that point because, you can't interpret something into the Constitution. The Supreme Court doesn't have the power to change the Constitution. They have power over congressional legislation and whether or not it is constitutional. And so whilst I do think that, I also think that it is integral to interpret the Constitution to a certain extent in order for it to not be a totally archaic document, because there's nothing mentioned about equal marriage in the Constitution, and yet because it mentions marriage in the Constitution, you can interpret that to mean both the marriages of opposite sex couples and same-sex couples, which isn't beyond that isn't beyond the powers of the court, because you have to find a way to stay up to date. But like Khai said, you can't interpret what isn't there.
And we're going to Ollie.
I'd also like to tack on a kind of counterpoint to that. If it were up to Congress to kind of regulate what they can't legislate on, then it would kind of defeat the purpose of a separation of powers. So they kind of need the ability to interpret certain things more vaguely, because otherwise it wouldn't apply to very much.
I think at some point it kind of does it. It's like a lot of it is reserved to states' rights, which I mean I somewhat like, somewhat dislike, depending on the state, obviously. But you cannot just revoke states' rights. And when it comes to Congress, a lot of times they do have the power to fill in the gaps in terms of the Constitution. And I completely agree with you, Abby. A strict constructionist should actually be in favour of the
Obgafell v. Hodges.
That one. Because it doesn't specify which marriage, which means all marriage is protected under the Constitution. So yeah, I completely agree with that. But when it comes to stuff like obviously Roe v. Wade, and I'm not saying I disagree with abortions, but because it does not say anything about abortions in the Constitution, it's Congress's job to decide what life, liberty, happiness means. It's their job to legislate upon what the intricacies of the Bill of Rights are. And it's also states' rights to do that, because I think that's why it's been left so vague in places, because the Founding Fathers understood that the Constitution had to change with the times, so they left it vague so Congress could continuously change it, and that's also why constitutional amendments in there. And we're going to Ollie.
I suppose a counterpoint to that would be that if Congress... Actually, I can't even remember what I was talking about.
And we're going to Abby.
I agree with your point about constitutional amendments and congressional legislation, and the fact that that's why the ERA was so important. However, I also agree with the fact that this is a flawed system, because the ERA did not pass. It was not ratified by enough states, by I think 2 or 3 states. And this has, massively hindered women's rights in America. And so whilst I think that it's more important and much more legitimate to pass congressional legislation or a constitutional amendment, I also think that interpretation of the law is necessary to protect what we now understand in our modern day and age as the human rights of people. And so whilst I'm not a huge fan of the judges legislating from the bench, if that's what it takes, then sure, fine. But I would rather they didn't. However, when it comes to a case like Brown versus Board of Education, that is not legislating from the bench, because it basically just it revoked the precedent of a previous Supreme Court case, which was Plessy v Ferguson. So that is not, as you know, as much as the racists go on about states' rights and, you know, we can do what we want. That's not a valid point on saying that Brown v Board revoked states' rights because all it did was say, no, you are behaving like you are giant, you know, arseholes that you are. But so when it's a case by case basis whether or not it's legislating from the bench.
Yeah, I somewhat agree with you, but I do have some, like, even if it was, you know, not voted through, the Equal Rights Act wasn't voted through by a couple or three states. The issue is if you're, that is the way you amend the Constitution. Like, just, that's like saying, oh, I'm going to pass this through the House of Commons, even though I was 3 MPs short of a majority. It doesn't really matter if you know, think it was very, very close and it should have been passed anyway. That's the way we amend the Constitution, and that is the safest way possible. So imagine if it was, you know, just half the states and half the half of Congress. Trump could, you know, amend the Constitution to eradicate, you know, term length or 4-year terms or something like that. So I do think it takes a very, very strong, necessary system to protect those rights and, you know, the democracy in the US.
So,
and we're going to Robert.
sorry, I think that it's very difficult to apply the originalist kind of perspective on the Constitution, because if you kind of look at the way that so I think that the Constitution, as it was formed back in the late 18th century, doesn't apply well to how we'd want to look at the legislation, the highest laws of the land in a modern context. Because if you take marriage, like Abby was talking about, the way that it was seen back in that time period wouldn't have really been in a great light in many people's eyes within modern society, because most people now in the US favor same-sex partnership, same-sex marriage, and then there are other areas as well which are perhaps too vague, so maybe there needs to be a way of informing the way that they're interpreted. Yeah.
And we'll go to Abby.
And bouncing off of Robert's point, the Supreme Court has, you know, its main goal has always been to ensure the rights of those it serves. So such as going back with equal marriage, even before Obgafell versus Hodges in 2015, it struck down the Defence of Marriage Act, which defined marriage as between a man and a woman, which is obviously that has been interpreted to be unconstitutional, because it nowhere in the Constitution does it say that same-sex marriage is protected, but because it doesn't specify that it's opposite-sex marriage, you can interpret that to be all marriage, which is that's an interpretation in the way that it's not putting something that is not there into the Constitution, which I think is what makes it more valid than the Roe v. Wade decision. And I am, in full favour of abortion and women's rights, but that particular decision could be seen, depending on how you interpret the Constitution, as unconstitutional.
One issue I have with loose constructionism is that judicial activism only really works when you agree with it. For instance, someone on the right might be really happy when judges are active and rule against abortion. However, someone on the left may be really angry or really happy when judges rule for abortion. So the issue I have with loose constructionism is you end up getting judicial activism, at which point the entire rights system in the US hinges on 9 random people every 30 years or so. Because think about it, if it was a different 9 people, there would be no access to abortion in the US. If it was a different 9 people, desegregation would have ended 100 years earlier. That is a real issue I have with loose constructionism. There's a political scientist, Jordan Lawrence, who says, "You do not hear what I am not saying." And I think that's actually quite a good case against loose constructionism, because you're taking your own opinions and you're ending up making the court, not neutral. You're politicizing the court, essentially. I know this is an argument we had in our class where is the court political or not, but yeah, this is a real issue I have with it because everything hinges on those 9 people. So we're going to Ollie.
But isn't the nature of like a judgment by the Supreme Court highly opinionated anyway? Because it's their opinion on the Constitution, so of course it's going to be divisive.
Yeah, I mean, you can never truly have a neutral judiciary, but I think the current Supreme Court is the closest we're ever going to get to it. Not the current one, but the US Supreme Court. I don't think it's that politicized because it's not. I don't think it's based on whether or not someone hates abortion or hates gay rights. I think it's based whether or not they think the Constitution should be interpreted. So, yes, it's at some points it is personal opinion, but once you get judicial activism, you get real opinions. You get what's her name, the most recent judge, Amy Coney Barrett. Yeah, the thing is if she brought her personal opinions in, obviously she would rule against anything that promotes abortion. But if you have someone like Ginsburg, she wouldn't have. But I think it's less about whether or not they hate abortion or hate gay rights, and I think it's because some of them interpret the Constitution differently. So I disagree with loose constructionism purely because you're allowing 9 random people to judge the fate of millions. And we're going to Aaron.
I'd make the point that I don't think it's fair to say that loose constructionism creates legislation for millions of people, because I think strict constructionism does exactly the same. But rather than creating new rights, it just restricts the rights that you already have, like abortion.
So give me your example for that. When's that happened? Or give me, a make-up example.
Well, like the Texas abortion laws at the moment, where they're restricting abortion, you could argue that that's a strict constructionist view of the Constitution, but all that's doing is just limiting abortion rights for millions of people.
However, I will counter that. The strict constructionists believe in precedent. That's why, if we went with the Democrats' perspective of it, the current Supreme Court would, chuck out abortion rights and stuff like that. But strict constructionists believe in, we've already set a precedent, just go with that. And the thing is with the Texas abortion, obviously it's pretty horrendous what they're doing, but you've got to look at what the Supreme Court actually said. The Supreme Court said each state must provide abortion to their citizens. However, they may be restricting it, but they're not, banning it entirely. So theoretically, yes, it's still constitutional, and that's why I think the Supreme Court hasn't, accepted to take that case again because they've already dealt with it. I think now it's up to Congress and it's up to the states to what they do with that. And at the end of the day, it's the people with the votes that decide, their state legislators and Congress people. And, it's their choice who they vote in. So at the end of the day, that should be a political issue, and it is. And that's how it gets solved, not through, 9 random people who could either vote for basic human rights or very much against it. And we're going to Abby.
But okay, so first of all, I think the Texas abortion bill is effectively a ban on abortion. I'm not going to go into why because that's not what this is about. Also, I don't think they're random. I mean, yes, they are 9 people. They are not 9 random people, but that's also besides the point. And it more comes down to, I agree with Aaron in the fact that it is kind of strict constructionists are legislating in a similar but still different way to loose constructionists. And Khai's point about precedent, well, surely that should invalidate Brown versus Board of Education, because what they were doing there was overturning a previous Supreme Court decision which said separate but equal is not unconstitutional. If you're going off of precedent, then that should be the ruling precedent because it's what came first.
At the time, it was for the time, it was a relatively, liberal, loose constructionist court, and that's why they overturned it. I think strict constructionists work with the most recent precedent, so they overturned it, and obviously it's a good thing that they overturned. What was it called?
Brown v. Board of Education.
No, the one that overturned.
Oh, Plessy v. Ferguson.
Plessy v. Ferguson. It's crucial that they overturned that, but obviously for basic human decency and stuff like that. But I think at the time it was a relatively loose constructionist court, so I think that's why they overturned it. And since there's a relatively strict constructionist now, it won't be overturned again. And we're going to finish off that point and move on to, do we have an imperial court? And for the first point for is there an imperial court, we'll go to Abby.
The Constitution, in the first 7 articles that was the original Constitution, it does define the powers of each of the branches of government quite clearly, and it does define the powers of the Supreme Court. And the power to strike down a bill passed by Congress is not written in the Constitution. And I think that, the whole concept of a branch being imperial is that it acts beyond its means, its constitutional powers. However, and so yes, I would argue that the court is imperial. However, I don't think that this is a bad thing, because it has been necessary for the protection of the human rights of various minority groups across the centuries, including obviously the ones that have been previously mentioned. So whilst I do think it is an imperial court, I don't think it's a bad thing. And I also think that there are still checks and balances enough on the Supreme Court that it's not an issue.
Yeah, I've got to basically completely agree with you here, Abby. It does overstep its constitutional bound, and I can see the shock on your face that we actually agree on something. It does completely overstep its constitutional bounds, but realistically, it does need the power to strike down Congress, but at the same time, it doesn't need the power to legislate from the bench. So I do think there's an imperial court, absolutely, but I'm very much in the middle. Should that right be taken away? Because I'd like to see a constitutional amendment that more clearly outlines the Supreme Court's powers. That'd be epic, but I don't think we're going to see that anytime soon, because no one will agree on what that is.
I also think it's not necessary, not really, because the UK Constitution operates almost entirely off of precedent, and so as the court has set the precedent of being able to strike down bills, congressional bills, that means that it's unnecessary to amend the Constitution.
And we'll go to Aaron.
I don't think the court is an imperial court, because I think it's just acting as it was intended to, which is as an equal to the executive and legislative branches, because I think it would be completely pointless to have a Supreme Court written into the Constitution that had no power to override congressional authority. I just think that completely defeats the object of it. So I think it's working exactly as the Founding Fathers intended.
Yeah, I relatively agree. They probably did intend for that to happen, but when you look from a strict constructionist viewpoint, they're completely overstepping their bounds. But in the end, we need that. So, Rob will go to Rob next.
I would also argue that there isn't really an imperial court in practice. I mean, you could maybe argue that they overstep the mark, but they are getting there in the way that they are intended to get there. They're appointed through the executive, and the executive is given its powers, and there's the checks and the balances. I would argue as well, like without the Supreme Court, there wouldn't really be any proper checks maybe on the executive or the legislature, like on Congress. So I think it's important that there is the Supreme Court, and that it does have the powers that it has at this time that it's always had, because I think it serves an important role.
And we're going to Ollie.
I was just going to make a point that was briefly touched on in terms of how the executive appoints the Supreme Court nominees. The fact that this has become a heavily politicized process, especially in recent years, would suggest that whether the court might be overall quite imperial, in recent years it's become quite imperiled because people have started to question the legitimacy of the court and therefore its decisions. So I think overall, probably imperial, but today I'd say it's quite imperiled.
I mean, that's a fair point. When it certainly has been questioned a significant amount by a lot of people, but I think those people are mainly just a bit butthurt that it hasn't gone their way, which is why judicial activism turns out to be such a big issue, for me anyway. It's because people only like it when it goes their way. And I completely agree with Rob's point that without, the powers that it essentially gave itself, the judicial branch would be completely useless in every way. And does anyone want to make some closing points before we finish off today? No? I guess that's it. Thank you for listening to today's episode, and I hope to see you next time.